So welcome everyone.
Yeah.
The Finance Minister Nirmala Sitharaman presented her fourth budget on 1st Feb 2022, setting forth the vision for India at 100. Our economy has shown resilience to come out of pandemic. However, as the Finance Minister rightly pointed out, we need to sustain the level of growth. Infrastructure, digitalization, technology empowerment, sustainable urban development, and of course, minimum government and maximum governance were the key highlights of the budget. Taxmann is delighted to host the budget marathon with industry stalwarts who will take us through the deepest and the finest points of the finance bill. Today, with our expert panel, we look forward to creating an insightful experience of amendments proposed in the budget on varied topics from direct tax laws, indirect tax laws, and corporate laws. I am C.A. Ridhma Bhatia, your moderator for today from Taxmann's Research and Advisory Department. Today's event shall have 11 sessions by 11 expert speakers in the next 7 hours. The agenda for the speakers can be viewed on taxmann.com/budget/marathon. This webinar is hosted live on Zoom, taxmann.com, Facebook, YouTube, Twitter, and LinkedIn. You may post your queries in the chat box or comment box. Our team will address your queries, and selected queries will be addressed by the speaker at the end of each session. We begin the budget marathon with direct tax laws having amendments in more than 80 provisions. So let's welcome our first speaker for today, Mr. Mukesh Patel, an eminent international tax expert and acclaimed author. A prolific writer accredited with over 4,000 weekly columns, 40 books, and 400 TV shows on tax and investment planning. He will help us today to understand the finance bill proposals related to functional taxation. Without taking much time, I request Mr. Patel to take over. Welcome, sir.
Thank you. Thank you, Nilima.
Yes.
I hope I am audible. Kindly confirm.
Yes, sir.
Thank you. A very good afternoon and welcome to this unique and one of its kind historic Taxmann Marathon post-budget. I think it has been rightly worded as a marathon because it's going to last 7 hours. Talking about Taxmann, I feel quite nostalgic because I have known Taxmann ever since I was a student at Commerce and Law when Taxmann came to be incorporated in 1972. I think by a very happy coincidence, 2022 marks the 50th Golden Jubilee year of Taxmann. And on this occasion, being almost like a part of the Taxmann family and having had a journey ever since I started my profession in 1977, again by a happy coincidence, the Taxmann magazine was commenced in 1978. And I fondly recall the founder and visionary, Shri U.K. Bhargav, with whom I have enjoyed and whose family I have enjoyed a relationship of more than 4 decades, almost 45 years. Out of the 50 years of Taxmann's journey, I've had a personal rapport for almost 45 years. And today I wish to, before I commence my presentation, I wish to, on behalf of Taxmann, welcome all of you, and also join me in greeting Taxmann in organizing this very eventful occasion. As my memory recalls, this is incidentally the 7th event that I am associating with in a big way with Taxmann, who has always supported not just quality tax education through its publications, but has also pioneered and championed the cause of tax policy making and reforms over the years. I fondly recall in 1991-92, we hosted jointly here, partnering with the Taxmann family, the Income Tax Bar Association, of which I was the president, the first All India Conference on Direct Tax Laws. In 99-2000, when I had the privilege of being the president of the Gujarat Chamber of Commerce and Industry, Taxmann again championed, along with the chamber, the National Convention on Direct Tax Policy and Reforms. Then came 2009, when jointly with FICCI, we organized a brainstorming panel discussion on Direct Tax Code 2009, when again, Taxmann played a key role as our media partner. Even more eventful was in 2015, when we organized the round table on direct tax reforms. That was also a marathon session, which lasted for nearly 4 hours, when so many key policy issues were discussed on a one-to-one interaction with the then Revenue Secretary, the Chairman of the Central Board of Direct Taxes, and top authorities of the Finance Ministry and the CBDT. Again in 2017, Taxmann and the All Gujarat Federation of Tax Consultants jointly had the privilege of hosting the first of its kind open house on CPC, on assessment and TDS related issues. And the outcome of that was that so many practical problems and hardships at the CPC level came to be very effectively resolved. But the latest, that was in 2021, the sixth event, when Taxmann, in the domain of policy making and reforms, hosted its sixth event. It was the All India webinar on faceless assessment. And I have a witness here with me in Dr. Pushpinder Puniha, who himself, in fact, laid the foundation as the Director General for the Faceless Assessment Scheme then, pioneering the vision. In fact, it was the vision of the Honorable Prime Minister and the Finance Minister, which was shaped and championed by Dr. Puniha. And I was very fortunate, along with the Taxmann family, to partner with the All India Federation of Tax Practitioners, the CBDT and the Finance Ministry, with Dr. Puniha at the helm, when we had a very meaningful interaction spread over a few hours, where we, in a threadbare manner, discussed several issues relating to faceless assessment. That was followed by an e-book with FAQs and a survey which was conducted, perhaps for the first time ever, once again with the initiative and dynamism of Taxmann. And I would like to make a particular reference of CA Naveen Wadhwa, who for the past few years has been a great asset here. So while I recall these 6 occasions, today is the flagship 7th event on its golden jubilee. In fact, almost completing the 7 colors of the rainbow. And therefore, I wish to take this opportunity to extend my heartiest greetings to the entire Taxmann family. The founder, late Sri U.K. Bhargav, whom we very fondly remember, his better half, Srimati Hem Bhargav, who is still there to guide, inspire with her affection and understanding. And we have, out of the three brothers, we lost one, but we have Rakesh and Raju, while we fondly remember Amit. And very proudly, the third generation, led by Ansh and his brothers, who are into the Taxmann family. So I wish to take this opportunity of greeting them, and I want to tell them that please continue this proactive approach, because we have seen, friends, when Taxmann was founded way back in 1972, you will all recall, many of you might not have been born. I was just a student at BCom and law, as I mentioned. That was when India had 97.5% income tax. It had 55%, in fact, 75% gift tax and 85% estate duty, 5% wealth tax. India had earned the title of the highest taxed nation in the world. That is what my budget guru, from whom I learned in 1978-79 the art of budget analysis, because I've had a long journey of analyzing budgets ever since 1977. By a happy coincidence, Nirmala ji's this 22 budget has become the 47th budget for me in a row to analyze. And for all these 47 years, earlier through my pen, thereafter through the webinars, and today through this great marathon, I am having this privilege and good fortune of joining. I wish to tell my co-speakers and all the participants that, of course, this is going to be an occasion where we want to light the lamp of learning. We want to be educated more about the provisions of the Finance Bill 22. But along with that, let us not just analyze and explain. Let us also try to be, as was said by our great national leader, Mahatma Gandhi, be part of the change we want to see. Because from those days of the 70s, of the highest taxes, today we have ushered into a scheme where we can say that we are in the league of world-class tax rates and world-class tax administration. I'm sure other speakers will have views to offer on this. But before I come to my subject on this inspirational and motivational note, I wish to submit that let this Taxman's marathon today lead the light for the change that we may want the policy makers to consider in terms of the provisions of the Finance Bill 2022 that we shall discuss. I shall be referring myself to some of them. But if all of us partner together, I think we have a great future ahead. In the opening remarks, the young lady mentioned about this being the 75th Amrit Kal of India's independence. We have had a long journey. We've been fortunate to have a budget where the finance minister, backed by the vision of the Honorable Prime Minister, has laid a roadmap for India at 100. With this future vision, we also want to carry the vision and mission of India's tax structure, India's tax administration ahead. We have seen challenges, and I only want to take 2 minutes to share through the memories as they come across to my mind, some of the historic couplets of finance ministers as they shared over the years. I am reminded of Dr. Manmohan Singh when he rose to present the budget of July 91. I was in the House of the Parliament in Lok Sabha. That was the time when India was in dire straits. Gold had been flown to physically been required to be flown at the IMF's diktat to Switzerland. And that is when the doors for liberalization opened. That is when we had an economist come finance minister who did not lose hope and who saw the vision for India when he said, quoting Iqbal, यूनान मिस्र रोम सब मिट गए जहां से बाकी मगर है अब तक नामो निशा हमारा कुछ बात है कि हस्ती मिटती नहीं हमारी सदियां रहा है दुश्मन दौरे जहां हमारा सारे जहां से अच्छा हिंदुस्तान हमारा. And in no time the Indian economy started turning around. 10 years since then, when we had another finance minister, Yashwant Sinha, who was also fond of couplets, probably he too, became the harbinger of this change when he said, तकाजा है वक्त का कि तूफान से जूझो कहां तक चलोगे किनारे किनारे. He also said, let's chart a roadmap of our own. I remember 2016 when we lost our Arun Jaitley ji very recently. But in 2016, he was in his full bloom during his tenure of 14 to 19. And this couplet will be almost immortal when he said, कश्ती चलाने वालों ने जब हार कर दी पतवार हमें लहर लहर तूफान मिले और मौज मौज मझधार हमें फिर भी दिखाया है हमने और फिर ये दिखा देंगे सबको इन हालातों में आता है दरिया पार करना हमें. And friends, we have indeed crossed the ocean. 2019, when Nirmala ji took over, even she had these two but beautiful lines to recite when she said, यकीन हो तो कोई रास्ता निकलता है, यकीन हो तो कोई रास्ता निकलता है, हवा की ओट भी लेकर चिराग जलता है. I think this chirag must have been inspired by one of the favorite couplets of Prime Minister Modi ji's compilation. And I will never forget. I think it is something for all of us to remember, because even amidst the challenges of the pandemic in the last 2 years, friends, India has risen to almost record a prolific, record-breaking economic GDP growth of 9% plus. It is only determined of the vision that the Prime Minister himself has when he often says, माना कि अंधेरा घना है, लेकिन दिया जलाना कहाँ मना है. So even amidst the darkness, let us try to light the lamp and not curse the darkness. This is what Taxmann has done for the last 50 years. Friends, this beckons us, inspires us to do even more as the times pass by. And with this 15 minutes of few opening remarks, I thought I have set the stage to start today. And may I request my team to please start the PPT for today as I go ahead and complete, my brief presentation, because the Finance Bill 2022, as you know, is something, as far as the spirit is concerned, what it offers. Will I be allowed to just share the screen, please? I think somebody else is sharing the screen, so. Can you start my PPT, please? Yeah.
Sir, you can share
Yeah,
the PPT.
it is full screen. Nikhil, full screen. Upar, full screen. Yeah. Page. So I'm going to touch up issues on personal taxation an updated return. Now, before I come to the proper subject of updated return, let me share with you, friends, the evolution we have all seen. There was a time when we were all, when June, July used to come and we would stand under an umbrella, queuing up before the income tax offices to file our paper returns with all those annexures and addendums. Times changed. We went into the era of e-returns, paperless returns. Then came CPC. CPC also has had a glorious track record amidst all challenges and difficulties of technology and various other challenges. It has done, I would say, a remarkable job. And I would like to, at this stage, make a particular mention of the CPC headed by its very dynamic chief, Dr. Sibichain Matthews. Dr. Matthews, if you are listening to me, this is a message for you. I want to compliment you and your entire team who have been doing a remarkable job at CPC, because 2022, Amrit Kal year, has evidenced that we receive our intimations not within days, not within hours, but we have instances where they are received within minutes. And gone are the days when refunds we had to wait and queue for our refunds. No longer anymore. Now, refunds come in no time, to the delight of the taxpayer. Of course, there is still a lot to be done on CPC issues, and on this occasion, I would only urge Taxmann that it's time that we take up our next project to deal with CPC-related issues. But coming to updated return, why and what is this updated return? Friends, you are aware, and let me give you a small example. Say, for example, for your financial year 21-22, you would be required to file your normal return, if you are a regular SSE, by July of 22. The latest that you can do under the provisions of Section 139, 4 and 5, if you have not filed a return, file a belated return, or if you have filed one, file a revised return. What would you do? You can do it only up to 31st of December 22, after which the doors are closed. So after that, if a return has to be filed, there is no way you can move ahead. And therefore, in this Finance Bill 2022, an opportunity has been given to the taxpayer that suppose he has missed out and he is now gently nudged by the specified financial transactions into the AIS, the annual information statement, as we call it, which again is a remarkable thing that is offered by the Income Tax Department, by the through the Project Insight and all its information technology, through its artificial intelligence and other things, that a taxpayer is able to know whatever the department also knows about him. And therefore, I often say this on my TV shows, कि आपके लिए ये जानना बहुत जरूरी है कि आयकर विभाग आपके बारे में क्या जानता है, क्योंकि उसमें अगर आप चूके तो friends, you would naturally go in trouble. Now, this time, the Honorable Finance Minister said that, within July to December, if you are unable to, complete the filing of your return, or if you have filed a return, but you realize later on that there are mistakes, you should be given an opportunity to update your return. And this is the objective of the entire updated return scheme, is very laudable. And that is what it talks about, an updated return. Next slide, please. Who can file and who cannot file an updated return? Because you are permitted to file an updated return, as we saw in the preceding slide, within 2 years of the end of the relevant assessment year. So the example that I was giving, say 31st of December 22 is your deadline. The relevant assessment year 22-23 ends on 31st March of 23. So 2 years since then, you can file an updated return until 31st March 25. There would be 2 time slots, one of 1 year, one assessment year from the end of the relevant assessment year, and another will be another year from that. So 1 year and 2 years, keep this in mind, friends, because there are separate provisions which are there in this regard for filing the, in respect of determining your liability for being eligible to file your updated return. Now, who can file and who cannot file? There is a category which is eliminated or excluded. And quite obviously, because even in the amnesty schemes or disclosure schemes that have come, it has never encouraged the mischievous taxpayer who has played truant with the department, and therefore cases of search initiated under 132, survey under 133A, where books of accounts, etc., are seized, requisitioned, or even in cases of prevention of money laundering, black money, etc., etc. These are all cases where you are not eligible to file your return. Now, if the policymakers are listening, and I would urge Taxmann to take up this issue for the kind consideration of the authorities, and that is, as far as the provision in regard to, I can understand if assessment is complete, you may be asked and you may be told it's not possible for you to file an updated return.
Sorry to interrupt. I think the slides have not changed.
It has not changed?
Yes.
We are changing, madam. I don't know. I'm on who can or can't file updated return.
I'm afraid, sir, it's the same as the cover slide only, sir.
Somehow, anyway, we are still on the cover slide.
I think you have to go to the slideshow part, and the other things will be visible accordingly.
Madam, we tried out this morning and it was working. I don't know what's happened now. Give me a second. Or maybe if you don't mind, what I suggest is let's come to without a slideshow, because my subject is not very complicated. I think we can do away the slideshow. The slideshow will not be required. Go off the slideshow. Just bring the regular full screen. Slideshow band kar do. My audio, my voice is completely audible. Close the slideshow.
Perfect, sir.
Yeah. So, yeah, I think we'll keep it this. You're able to see me, you're able to hear me. And I think my body language will convey what I wish to. And I'll try to be as clear and specific within the time frame of the next 20 minutes that I have to be able to do full justice to the topic that I have. Because as I said, more than, you see, information alone is information. Parting of information is not the only objective of this marathon. This marathon is meant to disseminate, analyze the finer issues, and more particularly, I would say at the end of the marathon, I would expect the Taxmann team to come up with a list of issues when we have a full cricket team of 11. In fact, I referred to Dr. Pushpinder Punia. I would like to make a very special mention of one of our very illustrious panel speakers whom we are going to in fact miss, I am told. He is none else but the Vice President of the Income Tax Appellate Tribunal, Shri Pramod Kumarji, who because of his challenges of work, has been required to travel. But I'm sure I would request Naveen and the Taxmann team to take his inputs as well on the subject, while his presentation will, of course, be taken care of by somebody. And I would like to also say it is a very happy coincidence that you have almost a full cricket team, of 11, experts who are going to be contributing on all different subjects. So catching up from where I was talking about this updated return, as I mentioned, the challenge is, and this is a point which I specifically wish to raise, that I have no issues with the other eliminations on account of search, seizure, survey, black money, money laundering, etc. That is in spirit of the philosophy that you need not just give blanket pardon or amnesty. But as far as a taxpayer who misses the time limit on account of the pressure of the work or anything, and he wants to correct his mistake, just to tell him that, because a notice has been issued in your case, I can also understand if the assessment is complete. And when we are talking about assessment, I'm sure it is well known, but let me clarify that receiving an intimation under 143(1) is certainly not an assessment. Otherwise, you would virtually lose the opportunity because intimations come within no time. So we are talking of a scrutiny assessment. Now, of course, if you have not you have not done anything before the scrutiny assessment is completed, obviously, after the completion of the assessment, you should not be made eligible to rectify your mistake. But my issue is that if I receive a notice, and while the scheme keeps its window open for 2 years from the end of the relevant assessment year, as far as receiving the notice is concerned, it is only 3 months from the end of the relevant assessment year, because I file my return latest by 31st December. The time limit for issue of notice expires on 30th of June. So if in 22-23, I realize some mistake for AY 22-23, by 30th of June, before a notice is issued, that's fine. But presuming that a notice is issued and I get to know something, well, the present scheme has closed its door. I believe this aspect needs to be reviewed because it can work the other way around. What would be the human nature or instinct? Say if he receives a notice, he becomes ineligible. If he doesn't receive a notice, he is tempted to believe that the department doesn't know about what he wants to offer because it may not be there in the EIS. And therefore, he may say, why do I want to now bear that additional responsibility of this? So, this is something which can possibly discourage. And therefore, I would say, while I am on this issue, that this opportunity of filing even prior to the completion of assessment must be allowed, because in any case, you are very much, recovering the additional tax. Now, this additional tax also, as section 139(8)(a) and section 140(b), together, they have made provisions in this regard. I'm sure you are aware of it, that if the updated return is filed within the first year of the time period, the relevant assessment year's completion, there is a 25% additional liability. And in the second year, there is a 50% additional liability. Now, this additional liability is computed on the basis of what is stated in section 139(8)(a) and 140(B), that whatever works out as your normal tax and interest thereon under the various sections, both tax and interest. If you are under the impression that it is only 25% of the tax, you are mistaken. It is not that you will have to pay tax at 37.5. It will be 30% of your tax along with your surcharge and cess, if any, plus your liability to interest and 25% of that. Moreover, though the word fee is not specifically used in section 140(b), it cross-refers to the provisions of section 139(8)(a), where there is a reference to the word fee also. So suppose there has been a late return that is filed where maybe earlier we used to be required to pay 10,000 rupees, now 5,000 rupees, whether or not in respect of this fee, there will be this additional 25% liability is still a little bit of a gray area. The time limit for completion of assessment has also been prescribed. The normal provision that from the end of the assessment year in which you file your return, 9 months from that period, if you do not cooperate, there will be an ex parte assessment, best judgment assessment as we call it. And obviously, what is the incentive for you to file this return? Because if you really work out, it's a very complex formula. I was thinking loud, and maybe the other speakers might want to very briefly comment on this issue, whether we should make the computation of the additional tax simpler, because the 139(8)(a) with 140(b), the computations are so complicated. I think there can be differences of opinion, and certainly the finance minister, as she mentioned, she does not want more litigation. So I was only thinking loud, can we have the formula a little more simpler and easier? That would be really worth it. And as I said, the real practical response and success of the scheme will depend that you allow a taxpayer to also step in at the stage of the continuation of the assessment proceedings while they are pending. So these are some of my observations on the first and important topic of updated return, where, I wanted to say, and give some practical aspects also for your consideration. Then obviously, it's not going to take me more time as far as the other topics that I've been allotted. As you are aware, the next point is tax relief to COVID patients and their family. Now, obviously, this was an announcement that was made in May of 21, when taxpayers were told, and I think this is a very welcome measure, the government announced something and they have adequately drafted it here in the legislation to provide, there are two provisions in respect of the COVID relief. I wish, there was something more by way of work from home allowance, etc., on account of COVID. But this is those who have suffered on account of COVID, and it's directly to do with medical treatment, reimbursement, and of course, compensation in case of death. Now, there are two provisions which can otherwise, if not provided specifically like this here, could attract liability, and that would be under section 17, where employer gives something to the employee or his family, and that can be treated as a perquisite. Or if somebody other than an employer gives, or if an employer gives to the family members of the deceased, etc., they could come within the provisions of section 56 as taxability under income from other sources. So in respect of these, the very welcome changes have been made, that section 17(2) states that, this will be treated as an exempt perquisite. Section 56 says, again, it classifies it in two parts, that if it's money coming from the employer, there is no financial limit, it can be any amount. And if it is other than an employer, it will be rupees 10 lakhs. Logically, understandable. And kindly note that this provision is made effective from financial year 2019-20, assessment year 2021, when actually the COVID impact started. Now, here my only little suggestion is that you see what happens to your assessment year 2021 return, which you had already filed and where you had, say, offered something as taxable or it was treated as taxable. Because before this announcement came, you are giving this relief retrospectively. But suppose somebody wants to avail of this, I think the board must come out with a circular saying that suitable cases, the commissioners or chief commissioners will be empowered, under the provisions of section 119 to grant relief, where otherwise an SSE cannot approach the department because proceedings have become time barred, for filing of a revised return or taking up the issue because the time limit has passed away. I think this is something which is another issue in regard to this, which I suggest this Taxmann marathon team should proactively bring to the notice of the North Block. Similarly, only this morning, Times of India here in Ahmedabad referred to the High Court's directions where it told the state government that COVID compensation, which has been delayed, as per the norms of the state government, the actual payment has been delayed, that should be expedited. Now, here is a problem, because the section, as amended, provides that when you are receiving something from somebody other than the employer, where there is this limit of 10 lakhs also, they have put in a time limit of 12 months from the date of death. So what happens that if somebody has passed away, the compensation is not received within 12 months for no fault of the family, as I mentioned, because of the delay on account of the government or the relevant authorities, etc. And then, say in the 13th month or thereafter comes the amount of compensation. By a literal interpretation, the amount would be taxed. I personally don't see any reason when you are in fact making this provision even retrospectively applicable. Why do you want to cap it with this 12 months period? I think a more objective view should be taken in this regard. There are 3 minutes and 2 more issues, but shouldn't take time. One is obviously NPS once again was expected because as we are aware, 2 years ago, in fact, it was Jetli ji who made that announcement then, that all central government servants within the framework of section 80 CCD, he said the central government's decision to contribute instead of 10%, 14% would logically be required to provide that 80 CCD also reciprocally does not tax that, that's allowed as a deduction. But that was confined only to the central government employees. This time, the Honorable Finance Minister has rightfully said that in order that state governments also can fall in line, from the same date as the central government, they have provided that 14% contribution, if made by the state government to its employees, would also be exempted accordingly. Friends, that brings me to the last provision, and I would try to and want to, in fact, stick to the time management part for the marathon, because that is when the relay race takes place. I think we are going to be 11 of us, one passing the baton to the other, second to the third, until the entire proceedings are complete, 8 o'clock. The last provision on personal tax, which I've been asked to speak on, is regarding rationalization of the provisions of Section 80DD, which, as you are aware, is in 2 parts. One is obviously the actual expenditure, which you are allowed as a deduction. And the second part is where, the person has taken, individual or HUF has taken an annuity for the dependent handicapped person, physically or mentally challenged member. And as was also pointed out, the memorandum to the provisions says and refers to the decision, the judicial pronouncement, that the conditions in regard to 80DD, saying that, the annuity or lump sum will be treated as exempt in the hands of the recipient only in the event of the death of such resident individual or member of the HUF. I think this was not practical, this was not pragmatic, and therefore a very welcome amendment has been made to remove the genuine hardship, and it has been proposed to allow the deduction under section 80DD if the scheme provides for payment of annuity or a lump sum amount upon attaining of age of 60 years. The moment you become senior citizen or more of the individual or member in whose name the subscription to the scheme has been made, I think I would very much welcome this decision. So with this, I wish to conclude and wish good luck to my colleagues who are going to follow. Thank you, Taxmann, and wish you all the best for the marathon. Thank you.
Thank you, sir. Thank you for setting the path for the marathon today. It was indeed a great session, sir.